All right. Good morning, everyone. Welcome to the Excavation Safety Alliance Town Hall, What Makes a One-Call Law Fair and Effective, hosted by Infrastructure Resources. My name is Whitney Price, and I'm the Special Projects Coordinator for Infrastructure Resources. And our ESA Town Halls are an open forum to discuss concerns and present potential solutions to improve damage prevention and excavation safety. A recording of the Town Hall will be posted on excavationsafetyalliance.com. And a short recap will be included in a future issue of our DP Pro magazine. Please know we will be posting the chat, so if you do not want your comment or name included, please indicate that with your comment. Please mute yourself now, and if you have a question, type it into the chat box and click the raise hand icon and we will unmute you. Today's meeting is meant to be a discussion, and you're all encouraged to ask questions and share solutions. Please try to keep your comments brief to allow others time to interact. And now I will let Tracy introduce herself and the panelists and discuss a few other key factors for today's discussion. Tracy?
Hey, thanks, Whitney, and welcome everybody. I'm glad to see so many folks on the call today joining the damage prevention discussion. This is one of the topics that is near and dear to me. I enjoy talking about effective enforcement and what makes it fair and effective for everybody. So I really appreciate that, and I'm pleased to be on this panel with so many great folks I will introduce shortly. But before I get into that, I do want a little housekeeping. We do encourage everybody to participate today. Even though you're muted at the moment, you have the option to raise your hand with that feature within Teams at the top. You can do the hand raise, you can use the chat, or otherwise get our attention, right? And we can all be part of the discussion today. So thank you for that. Whenever you do give a comment, whether it's in the chat or you come live on the call with us, please do indicate what state you're from whenever you start your communication with us. That will definitely help everybody stay aligned and get a better idea of where those ideas and best practices may be coming from. So as we think about a fair and effective enforcement, there are a few key topics that today may bubble up to the top. Some of those are going to be considering the pros and the cons when it comes to the type of enforcement, whether it's mandatory or complaint driven. So some of our panelists are going to share their experiences around complaint-based enforcement, and some of them have more experience with mandatory reporting and enforcement in their states. Exemptions is another huge topic when it comes to fair and effective enforcement of utility damages. So some of our panelists will talk about states that are specific to one utility type, and others may have experience where the enforcement applies to all utilities. So we would encourage you to gather, kind of think about your thoughts on that as well and share with the group today in our town hall. As time allows, an additional topic we will cover with our group here is damage investigations and what really goes into a fair damage investigation, where you collect the information from, the timeliness, and the details around that. So that kind of gives us a little bit of structure for our conversation today, and I'm pleased to present the folks you see on screen with me. Steve Allen is the Executive Director of Pipeline Safety with Energy WorldNet. He is a recovering state regulator, so his vast experience comes in with pipeline safety management systems, as well as some experience with NAPSR and other groups such as the GPTC or GPAC. And so Steve, thanks for joining us today. A lot of experience in Indiana, but you definitely have a wide view of the country. Kurt Young's president of Young's Excavating. Thanks for being here, giving us that perspective that we always need from the excavators. Louis Panzer, Executive Director of North Carolina 811. MG Govia, I said I was going to get that right, man. We practiced that. But MG is Education and Outreach Liaison with us from Okie 811. So thank you for being here as well. Shannon Neufeld, Technical Leader, Damage Prevention, and this is in our Canada Energy Regulator. And thank you, Shannon. Jerry Cabanas, Operations Manager with Excel in Minnesota, and also Josh Richards, allowing us to hear from a locator and damage prevention there with Excel in Minnesota as well. So as I toss out this first question, Jerry, I want to go to you if you don't mind and just kind of ask about your experience. Do you guys have mandatory reporting of damages? Is it complaint based? And what are your thoughts on that?
Mandatory reporting. I don't know if it's necessarily mandatory, but we do report on all damages. I don't know if it's necessarily a mandatory requirement for state law. They're required to report a damage, but as far as actually filling out any type of reporting, we do here at Excel, any line that gets hit, be it gas or electric, damage reports get filled out for anything that gets hit within our facilities.
So, Lewis, do you have thoughts on mandatory reporting versus complaint based? What have you guys seen the most impact? What do you feel might be fair and balanced for the group?
So as far as reporting of damages, that is a statutory requirement in North Carolina by the excavator. That doesn't directly translate to an enforcement activity. So the actions in enforcement are only complaint driven. So we've been in action here for going on our 9th year with our Underground Review Board, which is a 15-person governor appointed board. And we only field complaints that are filed. Those complaints can be filed by anybody for any violation of the law, and not necessarily be tied to a damage specifically. So we see that as pretty fair and balanced over the course of time, in that we've seen complaints come against operators, against excavators, by proxy against a locator. If they fail to do something to that complaint can be levied against an operator. And so we see that path seems to be making people happy, at least in the state of North Carolina. From it's not a knee-jerk reaction. Someone has to initiate it.
Tracy, we're kind of the same here in Minnesota. All of our enforcement is complaint driven, and again, it's not necessarily just on hits. It could be on, somebody digging around a facility that wasn't marked, so they call and complain. So we see a lot of that type of enforcement. When it comes to enforcement, though, it's, from all the years I've been doing this for, it seems like forever, but from the locating side of it to now the utility side of it, it's an unbalanced enforcement that we see in Minnesota here. We see the utility operators, being enforced far more superior than we see excavators being enforced. Excavators we see will get, enforcement letters, warnings and whatnot. But when it comes to enforcement, the operators, it seems like we get enforced on anything right away. We're the operator, we see the enforcements. When I was still part of CGA, doing the 811 CGA meetings here in Minnesota for 2-3 years, we'd get that report from MinOps where we'd see that the operators are fined $300,000 in 1 year. Excavators were fined $4,000. So it's just such to me, it's an unfair balance of how enforcement happens across the state. How utility operators are held to such a higher standard than the excavator that's actually putting the backhoe in the ground is.
Yeah, that's definitely a good point of view to put out there. And I do want to go to our chat. We had a question back to when Lewis shared 9 years is a legacy program at this point, right? Lewis, can you tell us briefly how the damages have increased or decreased over 9 years? Do you feel like the enforcement had a big part of the change there? And kind of talk to us about what you've seen.
So it's interesting. It took us a while to get our feet with this program, because anytime you change the law and establish one of these groups, the ultimate arbitrator, I guess you would say, is the Utilities Commission, but this 15-person group had to be established, had to be governor appointed. So it took us a couple of years to get things rolling, as well as the processes by which that review board fields those complaints and makes decisions as to whether or not a violation occurred. Also, whether or not they're using training primarily versus fines, which we have found that training was is 90, over 90% of what we actually apply is training in response to those damages. To actually say whether damages have gone up or down, is everyone knows here it's kind of a moving target. We do the best we can with the information that's provided. We feel it is keeping damages at bay, but most importantly, it keeps the stakeholders understanding there's a vehicle for them to go to if they feel that there's an issue, and it's not going to be necessarily one-sided against one party or the other. They're going to be looking at the information from each incident and making a determination if there was a violation of the statute itself. So keeping the stakeholders communicating and happy and not feeling that they're left on the sidelines is the most important aspect, in my opinion, of having this multi-stakeholder group to review and having it open to all individuals to complain. We get them from homeowners against other homeowners. We see them from, now we're starting to see quite a bit more action from the gas companies, identifying especially no-call hits and putting filing those in. So we feel like it's gaining steam, and it's unfortunate it's taken us, 8 years to get here, but this is a process. Nothing comes easy or quick in any of this. So we do feel like it's effective, and we do think it is keeping damages under control.
Thank you. MG, go ahead.
Yeah, I just wanted to say it sounds like we're about 5 years behind North Carolina and Oklahoma. There's been an evolution to the law. The evolution, I think, initially was just like, hey, who's going to be responsible for repairing this damage? And it was more to say who's liable, who's going to come in and after the fact and fix it. And then it turned into, well, now there's actually some people breaking laws. So in this last year, we've had updates to our laws for the last 5 years. And now mandatory damage reporting is a thing, but it isn't, like what Lewis said, isn't to levy any fines or punishment. It's just mandatory damage reporting. The places where the law has being enforced is going to be actually digging around pipelines. PHMSA wanted us to be adequate. That started in 2013. We started evolving this. We now have an enforcement agency, which is our Oklahoma Corporation Commission, but the law is only focused on pipelines. And so what they've done is they've taken it and they said, okay, this is a high consequence area. We used to care about damage and repairing of it. Now we're going to actually have the ability to punish or fine somebody who's digging around pipelines without a one-call ticket. So we're not waiting for damage anymore. Now you're breaking the law if you're digging without a one-call ticket. And so that's the latest, greatest thing. And then also we're just trying to clean up the communication with mandatory positive response, giving the operators an ability to go after excavators who are putting in excessive or fraudulent locate requests, things like that. So clean up the communication to hopefully improve the locating and response, and then also having the ability to go after somebody before a damage is kind of our two big things that have come through the last couple of years. And hopefully in 6 or 7 years, we'll be closer to where North Carolina's efficiency is, because I think we're turning the corner for sure.
Yeah, well, we can definitely learn from each other. And when we think about what we find in the various states, we didn't all start where we're at now. And I think that is important. As I turn it over to Steve, I'm going to ask him for some input just in general, but also some of the things that we have learned in the early years and making a fair and effective enforcement. We can share that amongst other states and have a different starting point, if you will. But go ahead, Steve.
Right. So much to say, so little time. And I want to say that Tracy and Kurt and I kind of go back a ways, all of us operating out of Indiana, and myself being the director of pipeline safety. Our program in Indiana is fairly mature, but at the same time, I think everyone recognizes that there are lots of opportunities for improvement. Is mandatory or is it complaint driven? Well, it's mandatory, but I can tell you there's plenty of complaints. Okay, a lot of people are having issues with with how the law is written, and basically it is the enforcement is only with hazardous liquid and natural gas pipelines, and there has to be a damage before there is any sort of enforcement action. It's been, I think, pretty effective in trying to get operators to comply with their procedures and to hopefully get their maps and records in order. You know, there's from a pipeline safety perspective, you know, state programs like ours, we were also able to basically penalize operators if it was a big deal. I mean, it was egregious almost. We're able to also penalize them under minimum pipeline safety standards, which the cost of jeopardy goes way up, I guess, when you bring that into play. So the big problem that I see, and I think Kurt, I'd love to hear your input on this regarding which underground facilities are covered. And right now, it's only, like I said, pipelines. From the standpoint of having you know, telecommunication infrastructure and whatnot, having any sort of enforcement action that we can take against them, it just was not. It was non-existent, and it was, for lack of better words, it was problematic. And I think where we've gone in the state of Indiana, there's probably been some unintended consequences related to the law, but it is very, very difficult to get the law changed. And honestly, Tracy, as you know, because we've put together a stakeholders group that we met every couple of months, and we would go all day long going around the horn talking about various issues and things that were giving us all heartburn. And we have 1 hour to discuss this, where quite frankly we could spend a whole week talking about this right now. So with that being said, I'll shut up, but I really would like to hear from Kurt.
Yes, thank you, Kurt. And then I'm going to go up to Shannon. So Kurt, there's a couple different things here, and you're welcome to touch on all of them around, I think it was Jerry shared initially that the utility seems to be an easy target for the enforcement. And some states, they don't see the excavator getting the heavy hand as often. But from an excavator's perspective, please just kind of reply to all of that, if you will.
Well, Steve was right. You know, when they redid the law, I think it was 2009, it took about 3 years to kind of get onboarded. And yes, it was damage related. The facility owners had to mandatory report it. And then it came out of the blue to the contractors because we were kind of left in the dark at the time. Well, now the secret is out. And it actually does work. A lot of contractors are pissing and moaning. They're paying some heavy fines. I mean, when you look at the dollar amount, because we have 3 or 4 major gas facility owners, and you can look at the fines they have to pay, it seems pretty substantial. But when you add up all the fines from all the different contractors, it's just about equal. So it balances out pretty well. Now, besides just being a contractor, I'm also president of NUCA of Indiana, and I also sit on the Indiana 811 board. So to Steve's point, yes, it is tough to change the law. Yes, we are going to be opening up the law the next legislative session, and we're going to be hopefully kind of aggressive in dealing with this. Now, the enforcement on the gas and pipeline side, believe it or not, works pretty darn well. The majority of the complaints that we see comes down to telecom. You know, the sewer and water municipalities, most of the time the work is being done for them. They're pretty on it. Telecom seems to be the Wild West show that is going to be a tough one to rein in.
Yeah, thank you. I appreciate that. I kind of can't get started on the telecom today. I have both ends of that. I've had great success stories in some of our states where our telecom partners really worked with us, turned a corner, and they have great strategy for calling in the tickets and maintaining a work schedule that everybody can meet. And then I have the complete opposite where I have one state that's looking at like 400 damages already this year because of one fiber installation project. So completely different ends of the spectrum when it comes to fiber, and that may be a whole nother conversation. Shannon, I'm going to go up to you and kind of see how things are going. What input do you have so far hearing this discussion?
Well, I just wanted to, I'm not sure what the complaint-based reporting is about, but the way it works in Canada, like the Canada Energy Regulator, we regulate every pipeline that crosses an interprovincial or an international border. So we are strung all the way across the country. The big difference with us is we have mandatory reporting by the company. They are required to report not just damages, but anybody, we've got a safety zone of 30 meters, about 100 feet, either side of the pipeline or the power line that we regulate. We only regulate about 1,400 kilometers of power line. But we've got this safety zone, and anybody excavating 30 centimeters or more, 1 foot or more, has to contact the pipeline company to get consent for that excavation, and they have to make a one call. All pipelines are required to be registered with a one call. That's the way it is. So they're required to report this, and we get about 400 we call them contravention reports, ground disturbance and stuff like that across the country every year. And what we're looking at is to see that the pipeline company is resolved, like as far as enforcement goes, they're resolving it, they're educating, they're doing all that fun stuff. Once we start seeing repeat contraveners, that's when we start to get involved a little bit. And we have an enforcement continuum. It's not perfect, it isn't, but it's the point behind this is we don't have very many damages, which is great, but we're trying to get an idea on what behaviors are being exhibited. Where should the pipeline companies, where should we focus our damage prevention efforts? And of course, I mean, contractors are the biggest one. Landowners, you have to have a different, well, you guys know this, I'm preaching to the choir here. There's a different approach with landowners than there is with contractors. But whether it's on private land, public land, or anything in between, First Nations land, our first concern is safety. And if you are in that safety zone, that 30-meter zone either side, you are required to make that one call. That's all I wanted to say for right now. I got a whole bunch of other stuff to say about fiber and stuff too.
We will come back. As I think about our discussion as maturing over to a lot of the data, and Megan had provided in the comments from Georgia 811's perspective and kind of their state oversight. With mandatory reporting of damages, you do get a lot of great data. So Josh, kind of being the front line on this whole topic out in the field, I'm curious, whenever it comes to collecting information about the root cause of a damage and who's hit us, what type of excavation were they doing, what type of tool were they using, have you guys found that having that data that comes with reporting has really impacted other parts of the business? Or just kind of talk to me a little bit about your perspective on this topic.
Sure thing. Thanks, Tracy. You know, when we have reporting, or when we have the type of reporting that we do here in Minnesota, it's patchy at best at times, you know. So we have some kind of mandatory reporting when it comes to natural gas and hazardous material hits. And then other stuff like telecommunications, you know, like a lot of the other states, we don't. Xcel Energy in-house, though, we keep track, like Jerry was saying, we keep track of all that information for damaging excavators and for all of our subcontractors. And we are, you know, making an effort to be able to track down and actually have metrics on all of that. So being able to see, you know, contractor X had 17 communication damages in the last 12 months versus, you know, not knowing at all because typically telecom is not reported, or, you know, sewer and water, that kind of thing is not reported. Being able to see that, being able to know what we're dealing with, we can actually curb it. Jerry, you might be able to speak to this. We have a I forget the name of it, but it's our red list at Excel. So we have an extensive list over the years of all the contractors that we've worked with, which ones are more likely to have a damage and what kind of damage are they having. And being able to see that, we can kind of, curb what we're doing. Maybe next year the contractors or subcontractor at least that's having a little more damages, maybe they get a little less of the contract next year. You know what I mean? But yeah, and in our end of things and locating that, that definitely helps everything on a just kind of a broad level, because then we're not sitting here running around trying to put out fires all the time for things that could have been avoided.
Absolutely.
What Josh was saying, we do have what we call a frequent offender program.
Yep.
When excavators hit our facility and it's their fault, it goes on a frequent offender tracking sheet. And what we use that for is for an outreach program. The next year, we'll build an outreach program and reach out to these excavators and offer free damage prevention presentations. So we'll go out and educate these contractors, let them know what we can do to help them if they're having problems with locates, or if they're having problems with facilities being in their way, or whatever it is we can do to help them. But the idea behind it is to partner with these excavators that are on that list to build a better damage prevention program with their company. Because there's a lot of companies that don't really have a damage prevention program. They just get locates to go and do the work, and they don't really have a designed damage prevention program, that they follow. So we try to help. We try to help those contractors that are having those troubles hitting utilities, build some type of a damage prevention program. We can assist with that. We get we sometimes utilize the CGA's best practice manual and give it to them, and try to help these contractors just be better at what they do to help minimize damages.
Sure. And I think when that data comes into play, it's extremely valuable. And as we collect damage data, it gives us more angles then to say, okay, what kind of training and outreach do you need to give to the stakeholders? So
Actually,
whether it's enforcement,
we definitely don't go to those excavators, and just try to beat them up saying you keep hitting it, stop doing it. That's not the intent at all. We let them know that we do this strictly because we want them to, to be a better excavating company when they're digging around pipeline facilities, and just kind of explaining the dangers that come along with all that. And, we just want to see them, evolve and be a better company doing what they do.
absolutely.
If I chime in.
Stephen, I had Shelley waiting patiently. I told her I'd get right to her.
Okay.
And then I'll jump back to the panel. So Shelley Dornick, thanks for joining the conversation. You should be able to come off of mute now. Whitney's going to take care of that for us. And then Shelley, go right ahead.
Yeah, Shelley, you'll be able to unmute yourself at the top right now.
And Shelley, maybe on Tracy, you called on me when I stepped away, or she's busy. I'm not sure. But Steve,
I could just jump in real quick and then I'll shut
please.
out. But
Hi, I'm sorry. Can you hear me
never mind.
okay?
I'll back out.
Thanks, Shelley. Yes, we can. Welcome.
Okay, sorry about that. My mouse decided to stop working and I couldn't get to my unmute button. So I just wanted to jump in and explain a little bit about what we have going on here in Colorado. So Colorado did create an enforcement mechanism at the state level in 2018. It is a complaint-based system. It's out of the Division of Oil and Public Safety, and it is a 15-person commission. However, our law did create a caveat for home rule cities in Colorado that says they can either defer their program to the state or create their own. So Colorado Springs, and just a little background on who I am, for those of you who may not know me, I work for Colorado Springs Utilities. We are a 4-service municipality here in Colorado Springs. And I have been with Colorado Springs Utilities for about 25 years and in damage prevention for most of that. So, what Colorado Springs did was we decided, because we already have worked very hard to build relationships with our local area contractors. We decided to bring our program local, so we passed a city ordinance that that governs excavation within the municipal jurisdiction of our city. And unlike the state, excuse me, it is a combination of complaint and damage driven enforcement. So with the end goal of creating partnerships and changing behavior, not collecting fines. Although those fines are in place for those, you know, for those stakeholders who just continually ignore the rules, but it does cover everything from late locates to pretty much any violation of the state law or local ordinance. So where our state, like looking at 2021 statistics from our safety commission, they received 38 complaints and had, you know, conducted 9 hearings. Well, 24 of those complaints were withdrawn because we, you know, we have facility owners monitoring that complaint roster, and if they see their name pop up, they reach out to that stakeholder and resolve the issue, which does not fix the larger problem. But so if a complaint is received at the state level and the incident occurred in Colorado Springs, that complaint will be referred down to our program to review. And stakeholders do not have the ability to withdraw complaints or violations out of our local program, because that is kind of defeating the purpose. But this ordinance went into effect in 2021. We started out in 2021 filing 0 monetary fines. It was educational requirements only. So if a stakeholder received a violation, they were advised that they had required classes they needed to take. So in 2022, we actually started the actual monetary fines, and but our first course of action is always education. We want to educate. And you know, instead of fines as well, we may assess a large fine for someone who has had a serious violation, but we'll also either reduce or waive the fine completely if that stakeholder can provide the program information of how they're going to move forward and correct that issue. So we're really doing a lot to move the needle instead of just handing out fines. But I think so far our local program has educated a couple of hundred of excavation companies in our area, to include almost 1,000 individual excavators. So we are we're rocking and rolling here in Colorado Springs, and I just wanted to share that because I'm not a fan of the complaint-based system. I think it's not as effective as something that is looking at damages as well. So that's kind of where we are. Thank you for the opportunity to talk.
Well, I appreciate it, Shelley, and that is a different perspective, that states have regulations or rules they follow, but then allowing that home rule for the local city or town to have that own ordinance gives us a new twist. As I turn this over, I owe the microphone to Lewis and then to Steve. If you guys want to talk anything also about exemptions, you're welcome to kind of go into that topic as well. But go ahead, Lewis, and then Steve, you can join after him.
Yeah, so real quick, I just wanted to state a couple things. You know, Jerry's point about using the data is critical, obviously, to look for those repeat offenders. I know in North Carolina, if you are showing up under more than one complaint, that factors into the kind of penalty that you could receive. So we absolutely want to start the ball rolling with education, where it can be, where that can be best applied. But if you do see repeat offenders, then they come back in after they've already had training. At what point does the training not not resonating enough in order to get action. So they actually have it. We followed Virginia's kind of model. We can do up to 2,500 as a penalty per incident, but we have that broken out into five pieces at 500 apiece. And those are reviewed and applied to each complaint to determine whether or not it's been a repeat. Was it egregious? Was it super risky, et cetera? So those are some of the things that we would apply. But I do want to say that to what Shelley had stated about withdrawing, the ability to withdraw those complaints, we found that I think when people do communicate, it's not necessarily a bad thing if they've communicated it through and then determined that they could work it out and withdraw it. In North Carolina, at least, we really want to promote the dialogue before it escalates to a level of having to be dealt with in a complaint or in a fine or penalty fashion. I think the idea of people working together is at the core of the whole thing, at the bottom of it. And if everybody's communicating, that serves a greater purpose rather than just instantly applying a fine and creating barriers. And that's what I had to say. Thank you.
Thank you for that. Go ahead, Steve. And do you have any thoughts on exemptions?
Okay, well, I have to think about that for just a second. But anyhow, back to the escalating fines and repeat violations. I think, and you have to correct me if I'm wrong here, Stacy or Tracy, but in Indiana, I think we can go up to like $10,000 fine or something like that. It was pretty big, and that's just on the one call side. But anyhow, repeat violators, that manifests itself in the penalty schedule that the committee, the Underground Plant Protection Advisory Committee, then recommends to the commission as far as a level of penalty, that being monetary and or training. And that training can escalate all the way up to, senior management of an excavating company. So I just kind of wanted to mention that. As far as exemptions, from a pipeline safety perspective, there are none. The idea that you have a group that is exempt from the law from PHMSA's perspective is kind of a no-no. And I think I saw in a comment somewhere earlier about how most states now are deemed adequate. The notion of having exemptions on the books seem to keep a lot of states from getting that adequate sort of rating. So, but even though I don't think that an exemption is exactly right, from a common sense perspective, there probably are some, but I don't know that I really want to spend the time talking about it. So anyway, I really want to talk about the repeat penalties. So, all right.
Thank you for that. I appreciate it. Exemptions for me, we represent 7 different states. So as I start to learn the laws and navigate what drives behavior change in each one of those states, it's interesting that it's not always the enforcement. I would have thought that it was the safety. And I will tell you that I can talk about, hey, this is a safe thing to do. Somebody might get hurt, but really the enforcement added onto that message is kind of what drives that behavior change. We have a state we operate in where really the enforcement doesn't start unless the damage is more than 16 inches deep. So if they hit a service line of any kind, whether it's cable, fiber, gas, water, if it's a shallow, less than 16 inches, it may not even get reported. Or if it's a homeowner digging on their own property in another state. So a lot of different exemptions still exist out there, and they may not be reported as exemptions or even recognized, but I have the experience across our states that tell me when the exemption exists, it kind of sets the tone for how important damage prevention is. And we just kind of think about that as a whole when it comes to that. There's a lot of great things here in the comments. I'm going to scan through a few of these, but MG, you guys in your program over there, do you have any exemptions or any thoughts around that?
Yeah, I think I've read this in a lot of states where routine maintenance of property. So it's kind of on the property owners who may be agricultural or homeowners doing landscaping, right? And so it kind of gives them this false belief there's never anything underground. But what we have done is made an exemption to the exemption. So if you read our definitions, we took the exemption away by defining where right-of-ways and easements are. So it talks about routine maintenance of your land, but then later it says excavation is doing, or excuse me, damage prevention is doing any work around or near right-of-way or easements. And it doesn't give a distance, which is beautiful. So it doesn't matter if you have 1 acre or 40 acres, you're probably around a right-of-way or easement, so you always have to have a locate. And then it also has a however statement that if you are familiar with where the lines are, you may not need to call in a locate request. However, if any damages occur when you don't have a locate request, you will be responsible for repair. So every exemption we've put in the however statement to remove the exemptions. And so that was the fancy legalese to make that work.
Yeah. So it's kind of like, hey, you don't have to here, but if you had a damage, you're still held liable for it. If
Right,
you
exactly.
choose to work under this risk,
Mhm.
then you're still liable for the consequences.
Exactly.
Okay. You know, I'm definitely entertain other thoughts around exemptions because it is a big part of fair and adequate enforcement. But we have a thought here from Alan. I was reading in the chat that when we send notification to the person that hired the excavator, do we see that that makes a difference? And there are some KPIs out there that show when the at-fault party is who they're doing work for. And so I think it's very common on our one-call tickets, who's the work being done for is kind of a standard field. So whenever you're investigating a damage, do you guys have any experience with that, Josh? Do you collect who they're working for? And does that play into kind of who you reach out to for the corrective action when you're telling them, hey man, these guys are working for you and they're over here cutting utilities? Or do you just go directly to the excavator every time? Josh, what do you guys do with that?
So over at Excel, we have a general reporting form for all utility damage, all hits, and we gather every single little bit of information we possibly can. So, you know, who they're working for, what they're doing, even down to what equipment they used while they were there. And we're able to gather metrics on all that stuff. As to how we apply that, we do end up having, you know, a very detailed list, like I was talking before, of all of our hits, all of the damages that have happened around at least state of Minnesota, and we can kind of curb where we're going to put or invest more time into, you know, who needs help, who needs more education, that kind of thing.
Gotcha. Well, I appreciated that comment coming in, talking about not only do we talk to the excavators, but public awareness efforts, reaching out to who hired them, who they're doing their work for. Kevin, you should be able to unmute yourself in the top right corner now. So Kevin, if you've got something to share, please go ahead. And I should probably say it's Kevin Hennessy. There's a few Kevins on the line today, but I seen Kevin had his hand raised, so when he's able to join the call, jump right in.
All right, Kevin, yeah, you're able to unmute at the upper right there.
And as Kevin navigates that, he's probably like, okay, now you call me. There you go.
There you go. Hi, my name is Kevin Hennessy, State of Oregon, Pipeline Safety Manager. Did a little work with Steve, so yes, he is a recovering regulator. But to my point real quick, on what we've, as far as holding outside parties or potentially contributing parties to the expectations of working safely, dig safely, it's really hard to do without a specific rule or an enforcement mechanism to go after that party. What we have found, and it hasn't been brought up yet, is that we've partnered with the Department of Labor Oregon OSHA safety program, and that targets specific worker safety issues related to employers and employees that engage in construction activity, including excavation activities. and to reach out to, say, the developer or to the general contractor as opposed to just the sub. There's a provision that we have worked with Department of Labor on that's called a multi-worker site violation. And I don't enforce it, but I'm a partner. I'm more of like a complainant to that. And so what we do, I try to do is collect as much information that supports that, hey, this is a layered expectation that someone was pressured into violating the rule. Oregon OSHA has the ability through their statute to create the expectation that it's a larger responsibility. But without that statute, without that enforcement mechanism, it's really hard to do. That's all I wanted to say.
Yeah, thank you very much for that. You know, a lot of our discussion is about what contributes to fair and adequate enforcement, whether exemptions make an impact or not. Is there anybody that wants to share something that really feels like it tips the scale to make it unfair? Is there anybody that could share an example, even chat or otherwise, of where there was enforcement or a lesson learned that, hey, you know, this doesn't work for us? Whether, Kurt, it's on your side of the house and you're like, yeah, when this happens, you're not really taking into consideration the other party. So Lewis, if you want to speak up to that, please do.
Yeah,
and then I'm going to review this comment here from Mike Evans. Has some good comments from Telecom. If you're not checking the chat, you might read what he had to say. But Lewis, please go ahead.
Well, I was going to say it's interesting because if you're a large utility with a tremendous amount of work going on and fielding a ton of locates, it can be perceived that if somebody really wanted to draw attention to every complaint on the law about you, you would have an unfair balance over the mom and pop group that only creates a few tickets a year. Same thing goes over towards the professional excavators who have tremendous amounts of crews and equipment out there that are working so much every single day. They're just more likely to be called out again because they have more opportunities. There's just more risk involved. So for a fair and balanced situation to really work, those things have to be identified and understood and in some way managed in the enforcement process so that it's not unfairly dinging one or the other large parties. If you can introduce that education on a large scale and introduce processes and practices that help those entities reduce that and get engaged in it, that's the solution. But that's one of the things that we've seen, at least, that it could tip a scale. If you're a super large utility with footprint all over the state, yeah, you're going to be likely to, have some late locates, and that's just a fact. And the same goes for the large scale, excavators as well. Thank you.
Yeah, excellent. There's a lot in the chat as I go to Shannon here about holding locators accountable and when do you kind of do education versus the carrot versus the stick. Some really good thoughts here, and I appreciate everybody sharing. Shannon, please go ahead.
I just wanted to talk about because we're a quasi-judicial body, we have to apply the principles of natural justice. So all of our reports are coming in from the pipeline company side or the power line company side. So when we go into these deeper, like if they've resolved it and everything's good, they've gone through the education and everything's tidy, that's fine. But if it goes further, then we have to hear the other side of the story. We have to look at both sides. And when we have had damages, I wouldn't say it's about 50-50, but quite often it comes down to the pipeline company's management system of the risk of people digging around there. They haven't adequately addressed those issues. So we will apply a monetary penalty there. We have also applied monetary penalties to developers, to planners, to excavators, because they've failed to dig safely. They don't have the safe digging procedures or anything like that. So it's not a short process. It takes time, but we do ensure that everybody has their day in court, so to speak, or quasi-judicial court.
Thank you very much. And that's important that we do get all sides of the story. Kurt, please chime in here.
Well, what we see happen, because there's, enforcement over gas only, and not trying to call anybody out, but I'll just say a and unknown telecom screens tickets. So they knowingly don't send a ticket out to get located, and the contractor is going to hit it. And then the investigation done on behalf of said telecom is by the locator that didn't respond. So then months can go by, and the excavator will get a bill in the mail, of which is the excavator did everything 100% right. So now you're down to a civil matter because there's no enforcement involved anywhere to kind of tilt the scales of justice to see who is right and who is wrong. And it's one of the huge heartburns here in Indiana, that the contractors are up in arms, and there may be a revolt soon. We'll see.
To add to what
Partnership now, partnership, no revolting.
To add to what Kurt was saying, in those situations, it's very difficult for an excavator, especially a smaller excavator, to lawyer up. I mean, they just don't have the pockets that some of the large telecoms have, or whoever, I guess. So it's like they're stuck. I mean, it's a bit of a tragedy. And I don't know. I've talked to Kurt, and I've talked to a lot of people there in Indiana about it. And I think the only thing we can do is get the law changed. And good luck with that.
Yeah. Well, we definitely know that the conversation around fair and adequate enforcement ties to the billing and the claims, right? There's some discussion in the chat that talks about unfair billing. And when you just kind of send a bill to an excavator and you leave it up to the excavator then to defend themselves and prove they're innocent, that takes time. And to them, time's money. And so as we think about a shared responsibility and treating everyone fairly, our go-to should not be just bill the excavator, right? So there's a lot of thoughts on that in the chat, and I encourage everybody to check that out.
I would also encourage excavators to keep meticulous track of your downtime and anything that you're associated with that, so that you can, that's been very effective to combat some of this stuff. And there's going to be instances where you're at fault, but there's absolutely going to be, you need to be documenting everything that happens out in the field. We just say it to everybody, all parties, document. So you have recourse when a year or year and a half or 2 years down the road, you get a bill for something, you need to be able to go back and find that data.
I agree with Lewis. I mean, I think one of the things excavators should start doing more of is A, documenting what's going on the job site, and B, taking photographs. Once those lots get located, take some pictures of what's being marked. And, when a damage happens, not only do we come out and take damage investigation photos and rely on post-locate photos for damage investigations, the contractor has their photos to defend themselves when they're getting billed for something. They can look back at their photos and send them into whatever the utilities building and say, here, we've got photos of this being marked. I'm not sure why we're being charged for this.
That's excellent. And as I pitch it over to MG, I'm reminded that they've had some training, and even I think one of his podcasts talks about damage investigation and documentation. Also, Megan from Georgia 811 commented that they have a training that's specific on what to do after a damage. Whether you've damaged a fiber, a water, electric or gas utility, there are steps to take not only to protect yourself and the community, but also to protect that claim and resolution of that cost. So as we think about that, I know we're nearing the end of our time here. I'm going to turn it over to MG for his comments on this, and then I'm going to ask Whitney to close us out for today. Encourage you to continue to conversation in the chat here the next few minutes, and we can all refer back to that in this great conversation. So MG, over to you, and then Whitney, you're up next.
This has been an awesome conversation. I like seeing what the other states are doing, seeing how our damage prevention laws have evolved and the enforcement behind it. Like I began, Oklahoma's law started out just who's liable for damages. Let's figure this out. When it happens, what happens next? And one thing that I stress in our education and outreach is no party, at no time does liability just go, well, it was the operator, now it's the excavator. It never just flips a switch. When that damage happens, whether it goes to court or goes to claims. They just look at every step that happened until the damage occurred and go, hey, did the operator do everything on their checklist to prevent that damage? And did the excavator do everything that they should do in due diligence to prevent that damage? And with the proper documentation, showing that you called and locate, showing that you had positive response from everybody, taking pictures and showing how that damage occurred, you are saving face and hopefully getting out a lot of those claims. So I saw a comment, someone saying, hey, every job you're going to, you're documenting for a court case. I have encouraged people to realize that as well. And then also the most ironic thing is when I get a phone call from one of my member companies asking me if they can go after another operator for downtime. And so it's kind of a tough place because, as we all know, the 811 Center is the ambassador of both sides. I want my excavators to get their jobs done and get paid and move on to their next job, just as much as I want to make sure no damages occur. My member companies are happy. And so that conversation is tricky. But ultimately, what we stress is communication. And as Tracy has said a number of times, is that shared responsibility to move forward. And if you focus on those two things, hopefully that enforcement thing kind of becomes a smaller problem because everything's being done correctly in the first place. So again, thanks for this panel. I didn't plan on being the closing remarks on all that, but I do think I'm honored to be a part of this panel, and a lot of valuable information was shared. So over to you, Whitney.
All right, well, it looks like we're at time, but please feel free to stay on for a few minutes after we wrap up if you'd like to ask additional questions. On behalf of everyone at IR, I want to extend a sincere thank you to everyone who attended, participated, and shared their thoughts and solutions today. And a special thank you to our moderator and panelists for their insights and knowledge on today's topic. The recording for this town hall will be uploaded to excavationsafetyalliance.com, along with registration for next month's town hall on August 11th, titled, How Can We Get More Women Involved in Damage Prevention, Excavation Safety, and Construction? You'll also receive a link to a survey, including registration for this August town hall. Discussions like these will continue at the 2023 Global Excavation Safety Conference in Tampa, Florida, February 14th through the 16th. Currently, registration is 8/11, now through August 11th. And session abstract submissions are open if you'd like to submit a topic for a potential session. As a quick reminder, there will be a short recap from this town hall in DP Pro. So if you're not currently subscribed to print or digital, you can do so at dppro.com/subscribe. The survey for this town hall will now be posted in the chat and will also be sent via email. We will also post a link to the Global ESC abstract submission. Thank you again to everyone, and please enjoy the rest of your week.
Thank you, everyone. And I will ask the panelists if you have a few minutes to stay on. Anybody else that would like to join the conversation afterwards? We will call this coffee after the town hall. You're welcome to hang out. So hey guys, as we have some folks hanging out here, I want to make note of a few things in the chat. One thing to capture in our minutes is the idea that they can really only protect themselves as an excavator when they know that there's a damage. So I hadn't really brought that into the conversation or even my education pieces about what happens when you had a damage. You didn't know you hit a utility and they come back to you weeks or days later. You haven't had a chance to take the pictures and do that documentation. So it was something I pulled out of the chat as some future thoughts. Anything else from anybody hanging out on the call with us would like to unmute and chat? You're welcome to at this time.
I think being proactive as far as being an excavator, again, I'm not an excavator, but approach everything as though you're going to court. You know,
That's
take
tough.
pictures before, during, and after. We all have cameras now. We've got them phones, or it's there. We have the technology. Let's use it.
Hey, Kevin, and then Mike Evans. Mike, thank you for joining the conversation. You should be able to unmute. They're going to work on that. Make sure you can get unmuted. And I wanted to get both of you in here to clarify your questions or comments with the panel before we close today. So go ahead, Kevin.
Yeah, I just wanted to follow up on the documentation piece, and I really grasped onto looking at CGA best practices and how sequential in order they are with things. And right towards near the top is the documentation or the recommendation for excavators to document the site, before you work. And they have much better plain language than what I just tried to stumble through on that. But that's what we share with when we're doing enforcement. And we do hear, the frustrations when we're processing an enforcement. Well, what about this guy, or what about this, or what? And we are complaint driven. But what it comes down to is documentation and how organized they are to really look at the sequential order of this whole safety management process. And once that falls into place, creating the expectation is easier.
Thanks for that. I appreciate you chiming in there. And then Mike, I'm sorry, go ahead and share with us your thoughts on that.
Yes, an excellent panel discussion. I could say this. I've been in the business over 45 years, 28 with AT&T, 16 with Quest and CenturyLink, and now I'm a consultant for Mox Networks. And I also do all the locates and stuff through EarthNet, which is a Utilsphere. I always require from you get in your first investigation thing with an attorney from both sides, and you realize that, like somebody was just saying, that the documentation is so important for you to have. So I required that every one of our locators get a hit kit, which has an excellent video with it to show you, how you should measure and show your, take your 12 o'clock, 1 o'clock, 2 o'clock, 3 o'clock, 4 o'clock, all the way around the clock pictures, because depending upon the angle, you can say you were right there, but yet you find that if those angles don't measure out correctly. But and I've also been a member of the NTPC, the North American Telecommunications Damage Protection Council, for the last 15 years. Was the chair and vice chair for a couple of years there. And we always tried to bring excavators, contractors into our quarterly meetings. We give them some, value to come there besides the CGA book that somebody mentioned earlier, to, hand out to them, but also lunch or dinner or something like that. But to talk to them about, what they see out there, because we wanted to see it from their view, what we were doing incorrectly. And I think it was you, Kurt, talking about a problem that you had up there in Indiana. That should never happen with a telecommunications company. If they're doing their work and job correctly, that shouldn't happen, that you just send a bill to an excavator and not know that we either internally decide not to send a contractor, whether it's internal or a contractor locator out there. That's why we always require the pictures. If you went out there, you're going to have pictures, right? If you didn't go out there and you don't have pictures, it's kind of a telltale story. But there's a lot of discussion, a lot of help, and telecommunications, as you mentioned, is not the only one. You got your pipelines, you got your gas lines. Sewer companies, water companies typically don't report these things. I lived in San Antonio for 20 years. I'm now in the Houston area. Tried to work with them to get a program going, because just passing that cost, the damage cost onto the consumers is wrong. But there's a whole lot we could talk about, but great discussion, great group. Your audience, I think, had a lot of value, hopefully, in some of the comments I read out there. There's a lot to be learned, and I'd like to get the NTPC kind of involved with you guys involved with them, so we can kind of work out a partnership. The more partners you have in this business of damage prevention, helping both sides, the pipelines, the utilities, anybody who's has underground facilities, the better we all will be. It's difficult to look at that dirt report and say we're better or worse, right? It depends on who reports them and who doesn't report them. And I think, like somebody talked about for Colorado Springs, some people get to where they call the person and they all of a sudden they get taken off the list. But we should know about every one of those damages so that we can get better at this. I'm sorry, I could keep on talking, but I'll let that go.
No, thank you very much. I really appreciate it. I know we are nearing the end of our recorded session here. I know that ESA is excited to have all the partners. So whether it's association affiliations or individuals, continue to join the town hall, attend the meetings, and just become a part of that bigger discussion. So thank you for that.
Hey,
Thank
Tracy.
you. Thank you.
Yes.
Just to tag on to what Mike was saying there really very quickly. So from the standpoint of trying to document work being done ahead of time, and I think Kevin Hennessy would probably agree with me on this from a regulatory enforcement perspective, the old rule is if you didn't write it down, you didn't do it.
Yep.